Hi, everyone. My name is Jennifer Moss, and I'm an attorney in the area of family formation here in New York. And I founded my family formation law firm, the Law Office of Jennifer P. Moss, a few years ago. And I'm here to talk to you about donor conception and the legal aspects involved in donor conception. So, what is donor conception? Well, donor conception is when you form your family using donor eggs or sperm, also known as gametes, or donor embryos. So, there's different types of donations that can be made. There are frozen donations where you're going to a cryobank or you're going to an egg bank, or perhaps someone has already frozen for themselves or for someone else egg or sperm or embryos. And so that's a frozen donation. There's also fresh donation, and fresh donation is where somebody is going through the actual process of giving their specimen, sperm, or giving eggs, and they're going through the medical process of an egg retrieval in order to give their donation. So that's considered a fresh donation. There's also different types of donation in terms of who the donor is. There is known donor donation, also known as directed donors, and there's unknown donor donation. And that takes the form of open identification, open ID donation, or closed donation. Now, you generally find out about an unknown donor through going through a matching agency or going to a sperm bank or an egg bank or an embryo bank. With a known donor, that's someone that you know before you go into this process. That could be a family member, it could be a friend, a coworker, a friend of a friend, but it's essentially someone that you know before you become involved in this process. With a known donor, we want to go through the legal process of a donation agreement. And so that's something that is required in many places. And even if it's not required, it is a very good idea to do. Here in New York, it's required. And in many situations where you're dealing with a matching agency or with a fertility agency, they're going to require that you have an agreement. And the agreement is when you have a known donor. It's also when you're working with an agency and you've done a match and it's sort of an unknown donor, but it's someone that's going through the fresh process. They want to have these donation agreements. Now, what do these agreements entail? Well, these agreements cover medical aspects, who's going to be where, who's going to do what facility is going to oversee things, what are the parties' obligations. And that's really more the obligations on the part in terms of the medical aspects, in terms of the donor. Also, financial considerations. In some places, financial considerations include reimbursements. In some places, it's payment for expenses. In some places, it's compensation for someone's time and risk that they're taking to their bodies, and the inconvenience of doing the donation. In some places, there's no financial consideration allowed. And so it's important that you work with an attorney in your area that specifically knows about what is allowed and not allowed in your area, because it's very different from state to state and country to country. And that brings me to the attorneys. So it is a best practice throughout the United States and required by law in some places that you have independent attorneys representing each side. And what do I mean by a side? Well, I mean the recipient or recipients are on one side. Not to say this is an adversarial process, but there's a donation side, a donor side, and a donee side, the recipient side. So the recipients are represented generally by one attorney, while the donor is represented by another attorney. And if that donor is married or has a partner, a significant partner, we want that person to be a party to the agreement also. And why do we want that person to be a party to the agreement also? Well, because we want them to be obligated to some of the same things that the donor is going to be obligated to. Now, obviously, that spouse, if we have a sperm donation, the donor's spouse is not going to be also giving sperm, but we may want that person to refrain from certain activities so that we can keep the body of the donor a little bit more healthy than they otherwise might be if the spouse was not taking certain precautions. For instance, if we have an egg donor, we might want to put into our agreement, and we very often do, that they cannot travel to certain locations that are known for Zika, because that would create a risk that their body would become infected with Zika, that could be passed on to their eggs, and we'd end up with a child that is infected with Zika. And we don't know how that's going to affect the conception, and it certainly is a less safe medical situation than if the child did not have Zika or the eggs were not infected with Zika. So for those reasons, we also want to include the spouse to make sure that they're restricted in the same way and that they're supporting the process. We also want them to know and be part of it. And so just in terms of openness, it's a very good idea to have those spouses or partners be parties to the agreement. Something that people find interesting is that any child born of the donation is not a party to the agreement. And so if you have anything in your agreement, which you very well would, about privacy, confidentiality, future contact, the child themselves is not bound by that. And so while you may have every intention of not having the child reach out to a donor until they're 18 or something along those lines, if a donor is contacted by a child before they're 18, even though the agreement said that they can't be, there's nothing we can really do about that because the child is not bound by the agreement, and therefore the child doing something is not a breach of the agreement. Sometimes we do put in the agreement that the recipients, the intended parents, cannot help the child reach out to a donor, and they have to take certain efforts, reasonable efforts, to keep the child from doing that. But in the end, if a child does something, and they're not a party. So it's something to be cognizant of. Also, when we're talking about unknown donors, there is this idea that we don't want to call them anonymous donors anymore. And the reason for that is because there's nothing really anonymous about this anymore. And we can't really go into this with the expectation of anonymity because we have commercial DNA kits out there like 23andMe or Ancestry.com. And so it's very likely, and I think you have to have this in the back of your head, that even if you plan to maintain a certain level of confidentiality and privacy and anonymity, it's not really very valid to have that true expectation of anonymity because it is easy these days and will probably become easier and easier as time goes on to find out the DNA matches and to find out the identity of donors. And I personally don't think that that's necessarily a bad thing. I think that it's good for donor conceived people to know of their background and to know of their genetics for health reasons and for just emotional reasons. But obviously that's a decision for you all to make. But just understand that anonymity cannot really be something that we expect anymore. And so when I'm speaking to my clients, I am letting them know about that. Also, we don't really want anonymity 100% because we do want to have some sort of a method, and we put this in our agreements, as to how to contact one another or how to exchange medical information. If someone was to find out later on after the donation that they suddenly have the BRCA gene and that they're prone to cancer, well, we'd want to pass that information along to the donor conceived person or to the recipient so that they can take appropriate measures with that information. We don't want to keep that a secret because it could affect someone's health. The same goes in the reverse. If the donor conceived person, if the person born of the embryo or the donor gametes has leukemia, let's say, well, we'd want the donor to know that because maybe that could pose a potential threat or a concern for their own children or themselves. So we want to be able to pass along that information. So when we put our agreements together, we include that in our agreements. Now, we also include in there future contact and confidentiality. We plan for excess embryos. How are we going to deal with those? Can embryos or sperm or eggs be redonated? Is that permissible or not permissible? That's something that we look into, and that's something that we talk to the parties about, and we include in our agreements. Most importantly, we put in parentage intentions. And that's the intention that the donor has of not being a parent to any child born of their donation. And that specifically says that the donor intends to just be a donor. The donor intends to relinquish all parental rights and obligations, can't come back later and try to say that they are a parent and ask for custody. We don't want that. So we want to put that in our agreement. With the recipients, we've put down that they are intending to take immediate control of any of the embryos or sperm or egg, and that they are the ones that are responsible for continued payment for cryopreservation, for use, that they are the ones with the dispositional control and power and authority to make any decisions regarding the disposition of those gametes or those embryos, and that they are able to use them as they wish. They are intended to be the parents of any child that is born of those embryos or of those donor gametes, and that they will take control of those children and take on those parental rights and responsibilities, regardless of gender, of the number of children born, regardless of any congenital or other defects or conditions, and that it's essentially a no backsies clause, and that the donees, the recipients, are taking parental rights and responsibilities of these children, so that the donor doesn't end up having the donation undone. And so all of those intentions are memorialized in their agreement. Now, there's usually a second phase to this. Not everywhere do we have this second phase. In some places, the agreement might be enough. Here in New York, we need to have a second phase, which is a parentage proceeding. And that's something that is recommended in many places, and recommended here in New York, that you have a parentage proceeding that specifically has a court order that says that the donor is just a donor, and that the legal parents are the intended parents, and that we use the agreement that showed the parental intentions and the donative intent in order to get that order. And so that's something that may not be required, but is certainly advisable to do. So you should speak to an attorney in your area, and they can talk to you about what is required and what is just a good idea and a best practice. It's about risk tolerance as far as taking some of those extra steps, but it's important that you speak to an attorney about those things. So you ask them what is necessary to ensure that you will be the parent if you're the recipient, or that you will not be a parent if you are the donor, and so that you know what to do and what the process will be. Now, with an unknown donor, like I said, there are different processes. With a donor that you're getting from a bank, cryopreserved frozen donation, there's not going to be that same agreement. If it's an unknown donor that's going through a fresh donation, there will be some sort of an agreement. But if it's someone that's already released their gametes to their sperm or egg or their embryos to a facility, they've already signed consent forms with the agency. And so that says that they are relinquishing their parental rights and obligations and intend to just be a donor. So you won't have that same kind of an agreement. Now, you have special considerations if you're single, if you're LGBT, if you don't have a genetic connection. Some places embryo donation is not allowed, but egg or sperm donation is allowed. So you just want to look into some of that and ask those questions of the attorney that you're working with in your area. You also want to know what kind of compensation that I mentioned earlier is allowed. Is it expenses? Is it reimbursement? So don't agree to pay your donor for something when it may not be permissible. I've had a client come to me saying, oh, I agreed to pay my sperm donor $10,000. And I said, well, that's not really allowed. So let's talk about that. So that's something that you need to know. It is generally impermissible to purchase human tissue, and egg and sperm and embryos considered human tissue. So we have to kind of know exactly what is allowed in the area that we're working. And so that's why it's important to work with an attorney that is licensed in the state that you're in, so you can ask those kinds of questions before you make agreements that you're not going to be able to fulfill. You also want to consider taxation if you're a donor, because there is some precedent that donors, specifically an egg donor, has had to pay taxes on compensation that she received in relation to her donation, and that is taxable income. So that's something to be cognizant of, and I would speak to a tax professional about that, someone who is a specialist and an expert in taxation before you file your taxes, so that you know if you're required to do certain things. Also, similarly, there may be taxpayer deductions for recipients for some process, or some part of the process, I should say. These things are not inexpensive, and so you want to make sure that you were talking to the appropriate tax professionals I am not one of them, but an accountant or a tax attorney would be the right person to speak to. So talk to them about that. In drafting these agreements that we've been talking about, we want to make sure that we are adhering to any prior agreements. So if you are using embryos that were created themselves of donations, let's say a sperm donation went into the creation of the embryo, then you want to look back to that agreement and see if you're able to use those embryos or redonate those embryos, whatever your plans might be, because in many agreements, there is a provision saying that you're not allowed to redonate. In other words, the donation is only to a specific couple or person, and that if there is excess at the end, it might give directives that you may need to follow in terms of destroying or not passing on to someone else for the purpose of procreation. So it's important that you know the source of your embryos, the source of your egg and sperm, and to know if this is a redonation or not. Something that comes up sometimes is whether there's going to be an absolute donation or if there's going to be some reversion language. I generally am not fond of reversion language because I think that can undermine donative intent. And we want to be very clear that the donation that is being made free and clear and with full intentions of the donor being a donor. I think that can kind of mess with the parentage aspect later. We don't want there to be any gray areas about whether or not the intended parents should be the legal parents and about whether the donor should be a legal parent or just a donor. We want to make that very clear. And so what I would say is generally do not have reversion language back in your agreement saying that any unused sperm, egg, or embryos revert back or there's a right of first refusal back to the donor. And instead, the way that can be dealt with is that there should be an absolute donation, all of the sperm collected, all of the eggs in the group, or X number of identified eggs or X number of embryos be donated. And that if the person who was the donor wants those back, that there be a second agreement of a donation now from the recipient, who is the essential owner of those gametes or those embryos, back to the original person who may be the genetic source of those donations. So that gets a little sticky, but it's a question that you should be asking of your attorneys and how to deal with that, whether there can be a redonation, whether everyone wants a redonation, if there should be absolute language or reversion language. And that's something that may also be regulated a little bit by the statutes in your area. So I encourage you to speak to an attorney in your area. Again, that's licensed in this particular area and deals with family formation. And I wish you all lots and lots of luck with your family formation goals. Thanks. Bye-bye.